Hello and good afternoon. I would like to welcome everyone to today's webinar, Closer Look, the L1 Visa for Intracompany Transferees. Thank you so much for joining us on this Tuesday afternoon. We hope everyone's having a great day. And yeah, just before we jump into the main presentation, just want to go over a few housekeeping items. First, today's session will be about 45 minutes long, and that includes an audience Q&A at the end of the main presentation. If you have a question that pops up throughout the presentation, please go ahead and type it in via the GoToWebinar control panel that you should see on your screen. You can go ahead and type your question in and we'll try to get to it at the end of the main presentation. Please keep in mind, however, that we can only answer general questions about the topics discussed today. We cannot get into anything case specific or company specific. In those matters, please consult with your immigration counsel for further information. Additionally, this webinar is being recorded, and we will send a link to download the recording after today's live session. You'll also receive a link to download the slide deck as well as the SHRM and HRCI continuing education credits. All of these materials will arrive in your email inboxes tomorrow afternoon, so please keep an eye out on that message. And if for whatever reason you do not receive it, just please let us know and we'll be sure to send it your way. Final housekeeping notes, please excuse any audio or video interruptions that may occur as a result of remote work and just different parts of the country where we're located. We are not anticipating anything, but if you are experiencing severe technical issues, we recommend signing out and then signing back in, as that tends to fix most things. But again, this broadcast is being recorded and we are not anticipating anything, but just wanted to make a note of that. So moving along, I'd like to talk a little bit about Envoy Global, who for nearly 20 years, Envoy has been on a mission to fix the inefficient, confusing, and frustrating immigration process. Envoy combines top-tier legal services and market-leading technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 150 countries. We've averaged a 33% rate over a 3-year period, and we work with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And joining us today is Ryan Harris, a supervising attorney at Corporate Immigration Partners. With over 7 years of immigration experience, Ryan has advised businesses running the gamut from household name multinational corporations to small developing startups, most often in the high-tech industry. His practice has been primarily focused on non-immigrant visa issues and complex USCIS and consular adjudications that require innovative, strategic approaches. Ryan has also worked with the ACLU Immigrants' Rights Project and other various Bay Area NGOs to defend the rights of immigrants outside of the business context. Ryan, thank you so much for joining us today.
Thank you for the introduction, Eric. It's a pleasure to be with everybody. Happy to be here to speak on the L1 Intracompany Transferee Visa.
Awesome. So, Ryan, before we jump into it, I do have one more housekeeping slide, and it's just a quick legal disclaimer.
Sure.
And so with that, let's jump into today's main presentation. Kind of laying this, setting the scene though, and discussing the value of foreign talent. So in Envoy Global's 2021 Immigration Trends Report, we asked over 500 HR representatives from various companies around the country various questions, and interestingly, 82% of employers surveyed said they expect their foreign national headcount to increase or stay the same in the next year. And then additionally, respondents said 96% of survey respondents said sourcing foreign national employees is important to the company's talent acquisition strategy. And these are trends that we've seen kind of hold steady or increase over the last couple of years. And if you haven't already, our trends report has been released. When you receive the slide deck, you can download it via the link there, or you can download it via trends.envoyglobal.com. A lot of great information and insights in that report. And so as we move on to the next slide, Ryan, there are different employment-based visas out there. We just sent H1B electronic registration season was just a couple weeks ago.
That's right.
What are some other employment-based visa options for employers out there?
We've got the H1B, you're right, we just went through the lottery for that this year. As we see on this slide, we've got the TN for your Canadian, Mexican hires. F1 OPT is the student employment option that comes for graduates of US universities. If you've got PhD candidates, the O1 Extraordinary Ability Visa might make a good option. And today we're talking about the L1A, L1B. Those are two types of the L1 visa that is for transferring a company in from your foreign affiliate.
Yes, great, thank you. And so, yeah, let's dive deeper into the L1 visa, starting with, as we move on to this next slide. Yeah, so starting on this slide, Ryan, there are many ways employers can bring foreign talent into their workforces. So what are some of the general qualifying criteria for U.S. employers, and what do we need to know?
Thanks, Eric. Before we dive into this question, I just want to also just take a minute to acknowledge the time that we're in, that there's a lot of uncertainty that remains with respect to the COVID crisis. As those conditions improve and we all inch towards normalcy, we're going to start to see consulates that have been largely closed for the last year start to reopen, and those visa services start to resume. And then along with that, travel barriers will start to come down. There's a complex web of travel restrictions right now that has a lot of L1 programs kind of frozen in place. And so it's a really good time now to be looking at your immigration and mobility program to ensure that you have the pieces in place to take advantage of this really highly flexible visa category, and to ensure that to the extent you already have an L1 population, that you're strategically managing any L1 issues that come up there. And so taking a step back and looking at the program from an overview, we can look at the rules for eligibility for both employers and employees. Start with the employers. There's two major rules for a company to qualify. The first of those is that the employer must have a qualifying relationship with a foreign company, that taking the form of a parent company, branch, subsidiary, or affiliate. And the second rule being that the US employer must be doing business in the US and at least one other country. So this is for a multinational company to take advantage of the L1. So the most frequent example you're going to see with this is a US-based company that has foreign subsidiaries doing business abroad and bringing in workers to the US from those foreign entities. And then we can take a look at the major criteria for the employees on our next slide. Again, there's two major rules here. The first is time related. Your employee must have been working for the foreign affiliate for at least 1 year within the last 3 years. Something to take a notice of here is if your employee that you want to bring in on L1 has only been working with your foreign affiliate for about that 1 year, right? They're just coming in at the year mark. You need to be careful that when you're counting up the time that they've spent abroad, you have to subtract out of that any time that that person has spent in the US as a business tourist or any other type of visit to the US, right? So if you have somebody who's already been doing heavy travels to the US in their first year, say that adds up to 2 months, well, then you've only got 10 months of foreign employment, okay? So you always have to subtract that US presence out of that first year. So that's the time requirement. The second requirement is it's got to be the right type of job. And you saw at the outset here, we mentioned there's two versions of this visa. There's the L1A, and that's for managers or executives. And then there's the L1B, which is designated for specialized knowledge workers. And in our next slides here, we'll define what those two job categories, how you prove those cases.
Yep. So let's jump into the first one, the L1A. So I guess, Ryan, with the qualifying criteria, and then move on to validity period.
Sure. And at the outset here, you want to be sure you're approaching these cases strategically. It's not a simple form to fill out to make the case that you either qualify as an L1A or as an L1B. You want to work with an experienced practitioner to put together the facts and a company statement that will prove to a consular officer, if that's the case, if you're applying for this at the consulate, that your employee meets the criteria for each of these, either L1A or L1B. For the L1A, you can break that down into two types. Your executive is kind of an obvious example. This is going to be somewhat less common, but this is, you want to think of as your C-level folks, vice presidents, director levels, somebody who's exercising a lot of major discretionary authority without a whole lot of oversight. More frequently, companies are going to bring in workers under the managerial capacity version of the L1A. And so there's two types under the manager. The first is a people manager, right? This is what we all think of as a manager. This is the more intuitive case to prove. You've got direct reports where the manager has authority over hiring and firing, directing work, making decisions about compensations and promotions, right? Everything we classically think of as a manager. There's also a way to put together an L1A case, though, for a functional manager. And this is your sort of account executive or various other titles where you don't have direct reports, but maybe dotted line reports, or maybe budgetary authority. And the key here is that you need to make the case that this manager manages an essential function or organization, or a department or subdivision within that organization. For the people manager category, you also want to keep in mind that the folks under that manager's management should themselves be professionals, and that's defined as folks who have professional degrees, bachelor's or higher. So if you have a frontline manager that's supervisory, you want to be able to show that the people under their management have degrees themselves. For the time frames on the L1A visa, you are provided an initial stay of 3 years. So that first time you come into the US, you'll be granted a 3-year admission. When you use up that 3 years, you get to extend the visa classification in 2-year increments, and you get a total stay of 7 years. That's a hard ceiling. So once you hit that 7 years of L1 status in the L1A version, you want to either have moved that employee onto a green card, if that's available, or to a visa without a hard cap like the H1B. And so we'll often bring someone in on a transfer on an L1A and ultimately change their status once they're within the US to H1B when that becomes available. And those are numerically limited and subject to a lottery each year. We have a note here at the bottom, if you'll see there, the asterisk, that one advantage of the L1A can be that it has a corresponding green card category. We want to look at this with a big grain of salt, however, because the two don't line up completely in parallel. The standard of proof is going to be higher for this green card category, but it is truly a fast track and a fast lane to getting a green card. And so if you have someone who's very clearly at a high managerial level for their 1 year abroad, and they're coming into the US to continue performing that high level managerial function, then they may well have a fast track to a green card. And that's something you want to talk with your practitioner about at the outset of the case.
Great, thanks Ryan for diving a little bit deeper into the L1A. As we move on to the next slide, well, I was wondering if you can explain the L1A New Office in a little bit more detail.
Sure. Now this is something that's more a unique version of the L1A, right? This is not going to be applicable to a US headquartered company. The new L1A New Office is generally for a entity that is operating abroad and is opening a new office in the US. And they're sending in employees to do this. Now the qualifying criteria are that the employer has actual physical premises in the US. So you want to be able to demonstrate a lease has been signed or some kind of property ownership where the new office is going to be doing business. And then the same rules apply for the employee, that they must have been working for your foreign affiliate for at least a year or more in that managerial capacity. And there's also going to be an additional element here required, that the intended US office will actually support an executive or managerial position within 1 year of the approval, right? So you get a little bit of time there to get the new office started, but the evidence you're going to want to put forward in gaining approval of a case like this is that you have the business plan, you have expected revenues coming in that's going to support the need for somebody to manage that business and eventually manage employees within that office. So this one is more restricted. You'll see in the time frame that's on the right of the slide here, the validity period, you only get 1 year to sort of prove yourself in that new office. The renewals are granted in 2-year increments, but your total stay lines up and is the same as that L1A visa where you get 7 years total if you can get through the initial barrier of proving that that new office is going to be viable.
Got it, thanks. All right, so that's going to bring us to the next slide, which is the L1B Specialized Knowledge Intra-Company Transferee. So Ryan, you touched on it a couple slides ago, but can you go into a little bit more detail on the L1B?
Sure. So now we've gone through the managers. So if you have an employee who's sub-managerial level, who you're bringing into the U.S. to support your operations here, the big hurdles you need to get around for an officer who's reviewing this case, be it at the consulate abroad or with the immigration service here in the U.S., and we'll touch a little bit later on who is going to be looking at your petition and why. But the questions you need to get around are number one, why can't a U.S. worker do this job? Right? And the specialized knowledge you're bringing in is going to be the answer to that question. Stated differently, say, why do you need to import this specialized knowledge worker into the U.S.? Okay. The qualifying criteria are that the individual possesses specialized knowledge of the company acquired by working for the foreign parent, subsidiary, affiliate, or branch. And then how do we define specialized knowledge? You want to be able to distinguish this person in two ways. The first of which is from the industry at large, right? How is this person, if it's a software engineer, how does their knowledge within your company set them apart from other software engineers in the industry? And then you want to dive even deeper and demonstrate how this software engineer's knowledge is distinct from even that knowledge held within the company. So sticking with the software engineer example, questions you might ask, right? Did they help build the tool or technology that they're being brought in to work on? A different type of worker, think of a marketing or a salesperson. How will you distinguish this marketing professional that you're bringing in from your office in India or from Europe from any other marketing professional that's come in off the street to apply for a new job? What makes them special? What makes their level of knowledge special? In terms of the expertise, how are they maybe using your customers or using their knowledge of how your customers utilize your technology? How does that compare to what other marketing professionals in the industry and even within your own company set this person apart? So on both of those levels, both within the company and within the wider industry, you need to be able to distinguish that the individual has specialized knowledge. This visa type of the two, of the manager versus specialized knowledge, faces greater headwinds, more challenges, and so requires a great deal of detailed workup of the case in order to convince an officer that you really meet the criteria.
Got it. And what's the validity period for the L1B, and how does that differ from the L1A?
So similar here. The L1A has the advantage, remember that was a total of 7 years if we're working from the bottom up. The L1B is more time limited. So you get 5 years total, but your initial period of stay is the same, and then it's 3 years, and then you get a one-time 2-year extension of that status. So again, if you're coming up on 5 years within that time period for an L1B worker, you want to get them transitioned to either a green card, if that's available within that 5-year time frame, or transition them over to a more durable status like an H1B.
Got it. Great. Thanks for going over the L1B. And so that's going to bring us to the next section of today's presentation, and that's the L1 visa application process. So Ryan, as we move see here on this slide, I'm going to start with the blanket L approval. Can you explain this term a little bit more as well as the application process?
Absolutely. So you've identified your worker, you've got your facts together, you've strategized your case with the attorney to determine what type of worker you have, right? What type of visa, L1A or L1B, you're going for. Your legal team's drafted the documents, and then now what? How do you actually get the worker to the office in the US? The easiest fast lane way to do that is the blanket L approval. Some of you may already have one of these set up within your company. Some of you may be thinking about whether or not your company is eligible. What the blanket L permits you to do is to avoid any kind of interface with the immigration service here in the US, and instead go straight to the consulate in the employee's home country, present the documents that your attorney has drafted, and then within about 5 business days, assuming visa interviews are available, they can get issued the visa. Now, that's the end of the process for them. They get to travel to the US, then enter and start working right away without any need to go through USCIS. And that's the immigration agency that adjudicates petitions within the US. And we'll see in a little bit later in the presentation here, even more so how that is a benefit to be able to skip that step at USCIS. So the blanket L approval, once it's obtained, this is basically in the form of a list of all of the qualifying entities, both within the US and outside the US, under which an employee can apply for the L1 visa. It saves time, it saves money, it saves you from the additional scrutiny that's applied on petitions that are filed within the US. And then, next slide here. So if you're wondering, is my company eligible? If you don't already have a blanket approval, here are the basic rules that you have to meet in order to obtain that list and then use it to apply directly at the consulate. The first is that all listed entities are engaged in commercial trade or services, right? These all have to be ongoing business concerns. The US office that you're anchoring the blanket on has been in business for 1 year or more, and then that there are at least 3 domestic or foreign related entities. And again, these can be parents, subsidiaries, various types of corporate relationships. And then one of the following of these 3. The company must have obtained at least 10 L1 approvals during the previous 12-month period, right? And these are off-blanket approvals where you go and file individual petitions with the Immigration Service, which we'll touch upon next, or have US subsidiaries or affiliates with combined annual sales of at least 25 million, or have a US workforce of at least 1,000 employees. So if you have all 3 of these things under item 4 there, then you're well on your way to being eligible for a blanket L certification. And you would want to strategize putting that together. That's an application that is submitted to the Immigration Service. It can be filed with premium processing, meaning that in about 2 weeks, if your case is approved, you are issued that certification, and that is what your employee can use to then go straight to the consulate and ask for a visa. Jump to the next one.
Great. Thanks so much, Ryan, for going over the blanket L. And sorry, I accidentally skipped forward for a couple of seconds. So, Ryan, as you move on into the next slide, what are some other details our attendees should know about the L1 application process?
So the L1 application process depends on whether or not the company has the L blanket. So where you do not have that fast track to go directly to the consulate, right? If you haven't established with your attorney that you're eligible for the L blanket, you need to go first with your individual case to the Immigration Service and file a petition by mail. That case then goes into the Immigration Service with premium processing and an additional fee. You can get a response on that, or at least some type of government action within 2 weeks. Under regular processing, you're looking at more like 4 to 6 months. That processing time can vary pretty widely. The Immigration Service at this point in history is more on the slow side. And so without that L blanket, you have at least 2 steps you've got to go through. Once the USCIS issues approval of your petition, you then, with additional documents, send that package to your employee abroad. They show up at the consulate and present that pre-approval and are issued the visa at that point. We run into a lot more challenges and a lot more pushback at USCIS for the individual petitions. The consular route is by far the path of least resistance because a lot of L1 programs have essentially had been frozen when it comes to travel. We've had to use the individual petition more often when it comes to renewing L1s. And if you already have an L1 population, you're I'm sure familiar with this issue. We can talk about how to strategize that where you basically can't get around but going through the agency as we go forward here.
Yep. And for the final slide in this section, Ryan, what are some common documents that are needed for the L1A, L1B, and blanket L?
Right, so when you've identified your employee, what are some things you can start collecting for your legal team to analyze in order to assess whether or not you've got a good L1 case. So starting out at the top here, 12 pay stubs demonstrating 1 continuous year of employment. And this ties back into our legal requirement that the employee must have spent at least 1 year working abroad before transferring to the US. The pay records are the easiest way to prove this. Depending on whether you are an L1A manager case or an L1B Specialized Knowledge case will determine the types of documents you'll need to prove up that you've got the correct job type to be issued the visa. So for your L1A manager, some examples here are an organizational chart that shows the managerial organization and the direct reports of your managerial employee. You may also have contemporaneous evidence like assigning tasks, performance reviews that your managers sign off on, contemporaneous written evidence of executive or managerial decision making. Those are the types of things we would include in an L1A petition. For the L1B, remember we're focused on highlighting the individual's specialized knowledge that sets them apart from both the industry and from others within your company. So we'll start here with diplomas and transcripts. If you're applying through the L blanket fast track method of going straight through the consulate, your employee will need to have a bachelor's degree or higher. And so we can often, if it's a foreign degree, get those evaluated to determine the US degree equivalency. And then we're going to need to show evidence of that specialized knowledge. So if the employee has engaged in a lot of training, especially within your organization, it's proprietary to your company, those training records, or if they've actually given trainings themselves, right? Are there PowerPoint decks or written materials that they've distributed and authored that shows the level of their expertise and specialized knowledge within your company? Some other great evidence is something like patent approvals, right? Has this employee been involved in cutting edge technology to the extent that their name is on patents or authorship of technical manuals that your company publishes for your users to refer to? Those are the types of body of evidence that we would include in an L1B case. And then if you don't have that blanket approval, pre-approval done, we will want to work with you to collect documents demonstrating the common ownership between the US company and the foreign company, right? And this is on the case of an individual petition, that you've got to prove that relationship in every individual case. Once you've got the blanket established, this takes care of itself and goes away as a requirement because all the companies are listed on that blanket. It's all been vetted by the Immigration Service here. And so the consulate can essentially skip that step.
Great, thank you so much for going over some of the common documents, and that's going to bring us into our next section. But I do want to take a brief pause here to remind our audience that if you do have any questions regarding the L1A, L1B, blanket L, to go ahead for Ryan to go ahead and please type them in. And so yeah, Ryan, let's jump into our final section here, which are other considerations, which as you mentioned are pretty timely. So I'll take it away.
Thanks. Yeah, so that was sort of the intro to the L1 visa, or if your company's already using the L1 program, maybe perhaps a bit of a refresher course for you. Looking ahead, where I started here is noting that we may be having a thaw in travel that's coming up. In terms of use of the L1, the good news is that there was a ban on L1 and other visa types that had been enacted by the prior administration as a COVID control, travel control measure. That expired, in fact, and the current administration has not renewed that. So consulates are permitted now to issue new L1 visas or renew L1 visas if you've got folks currently on an L1 visa who need to add more time to that visa. So, right. The catch here is if you can get an appointment. Consulates around the world are still largely working in a sort of emergency only basis. If you have an urgent case that requires renewal through the consulate or an urgent transfer you need to get done, there are mechanisms under which we can apply for expedited appointments or what's called national interest exceptions. And so you want to work very closely with an experienced L1 practitioner to put together the case for one of those if you need to get in through a consulate that's offering emergency appointment. And fortunately, we're seeing in some places around the world, the consulates are actually starting to schedule just regular normal visa appointment services. Now, these are largely going to be sometime out into the future, with some minority of consulates, potentially you're able to get in sooner. Now, what remains a huge challenge is that the physical presence bans, and these are all a variety of presidential proclamations, are still in place for all of those countries under which they've been implemented. And there's a list here. It includes the UK, basically all of the EU, China, Brazil, South Africa, Iran, and most recently, India has been added to that list. The rule on these proclamations is that if you have been in one of these countries 14 days before your attempted entry, you would not be permitted to enter the US. So if you're in China and you already have a visa, right now you can go through what's called a green lane country, right? You can travel out to the extent you meet the local entry requirements to a third country and wait out a 14-day period there and then travel directly to the United States. The issue with these travel restricted countries are that they are essentially not issuing visas out of the consulates in these countries because of the travel bans. And so where you have somebody who actually needs a visa because they're a first-time transfer or because they're an L1 employee who's traveled out to see family or to do business abroad and need a new visa to come back, we're still in a waiting game to be able to resume normal visa services in these countries. And so again, if you have emergencies, you'd want to work with an experienced practitioner to put together that emergency case. Otherwise, we're simply looking at waiting out the virus and the pandemic situation to normalize such that these visa services return to these countries. Taking a step away from the COVID situation, what is always true for L1 status is that it can be notoriously tricky to track, right? And so there's a lot of nuance, and there are a lot of documents at issue. I-94 is a document that gets created upon one's admission into the US, the visa stamp that the consulate issues, there's the petition documents that are issued by the Immigration Service, and the I-129S, if you are an L1 blanket user, that is the endorsed travel document that comes out of the US consulate along with the visa. These documents will very frequently all have different expiration dates, and those expiration dates all have different and very significant impacts to the case. And so you want to be sure that you have a program in place where you have an experienced legal team to interpret those documents and their expirations, and a technology platform that helps you monitor these and report on upcoming expiration dates. The last bullet that I had here relates to using RFE flex time. So if we want to actually jump ahead to the next slide, Eric, this will kind of help illustrate the point. This is government published data regarding individual petitions, right? So this is setting aside the blanket fast track to the consulate. When you have to file a case with the government can either approve that case, or if they're not convinced that you have either met the 1-year requirement, say, or that they're not convinced the person is sufficiently, that their knowledge is sufficiently specialized, or if it's an L1A case, if the reviewing officer is not convinced that this person is truly operating at a managerial level, right? Maybe it looks like they're more of a senior individual contributor because you have kind of a borderline case. They can issue what's called a request for evidence, or RFE is the shorthand we use for that. And as you can see, even before our most recent administration, the RFE rates were fairly high, starting in 2015 above 30%, and then they really shot up as we go forward in time. What will happen under the current administration remains unclear. We're going to have to see how that shakes out. There are certainly an expectation out there that these numbers could start to come down, but as we can see back in 2015, they were still at a high level. So one can expect that we will continue to have challenges in the form of requests for evidence at the government service level when you have to file a petition with the service in the US. Then if we can jump to the next slide, Eric. These are the approval rates after an RFE. And so as you can see, fairly significant levels of denials once you get a request for evidence. So there's a high risk when you file at the service center of getting an RFE. And if you get the RFE, about 50% or higher chance that your case could potentially be denied. That is the reason you want to consider looking at a blanket if your company is in fact eligible for that. If you have to file a case at the service center, and this is sort of one of the strategic takes one can take in a COVID environment where travel is not possible, the government is actually offering an additional 60 days on top of what is normally a 2-month period to respond to an RFE. When a petition is filed prior to an employee's expiration, you are permitted 240 extra days just of work authorization while that case is pending. So in the environment that we're in with respect to COVID and slow processing times, this is actually a time in which you can actually take advantage of the government's slow processing times by filing a case under regular processing. If travel becomes an option later, when the consulates open up, one can certainly travel while that case is pending, even if an RFE has been issued, renew through the consulate, come back to the US, and petition could be withdrawn if there was any concern about a denial given these high denial rates. So some important strategic choices to be made with respect to L1s. The environment continues to change and shift as it relates to travel. So you'll want to be sure you have looked at these issues with your practitioner in order to make sure your L1 population is taken care of.
Great. Thank you so much, Ryan, for going over the other considerations. And with that, that's going to bring us to our audience Q&A session. We have been receiving some questions throughout the presentation. But if you do have any additional questions for Ryan, please go ahead and type them in. We do have a few minutes remaining. Just again, as another reminder, we can only address general questions on the topics discussed today. We cannot get into anything case specific or company specific. In those instances, please consult with your immigration counsel for further information. So Ryan, let's start with this first question. Does the L1 have premium processing?
It does. Now, when you're at the consulate, remember, you don't need premium processing because as long as you can get an appointment, you can show up and submit, and those are usually taken care of within 5 business days. When you have to file at the service center, premium processing is absolutely an option. But as I was going into my latest point, you don't always want a quick answer on these because there are headwinds, because there are so many challenges in the forms of RFEs, and on those RFE cases, a lot of denials. What you may want to do is buy time by filing a petition and letting it sit with immigration while we wait for travel to become more flexible as we go forward in time and as the COVID situation improves. And so there are a lot of considerations that go into whether or not you would want to file with premium processing. If it's a new employee that you're looking to get to the US as quickly as possible, it presents a great option if you don't have that blanket.
Great, thank you. Is there a dependent visa for spouse / children? What about work authorization for a spouse?
Yes, L2 is the dependent version of the L1. If once you've won your L1 case, the L2 is pretty easy. That you just have to be related to that L1 individual by birth or by marriage. So the L2 visa is what the dependents will use to travel to the US. Upon arrival, an L2 spouse, this is not available for children, but an L2 spouse can apply upon arrival for what's called an EAD. This is essentially a work permit. The catch is that it's going to take 3 to 6 months in normal times for the EAD to come through, and a spouse cannot start working until that EAD card has arrived in your mailbox. So there is going to be a time lag with respect to that, and there's unfortunately now no way to speed up that option, although premium processing may become available for those spousal EADs as well.
Got it, thank you. All right, so Ryan, next question, I guess, maybe taking it back to pre-COVID, and then if you want to touch on COVID and just the impact that's had. What is the average timeline to get L1A to acquire an L1 visa?
To acquire the visa, so from case initiation, right, where you go to your legal team, you pass on some information about the worker if the case has been assessed. Generally 3 to 6 weeks to prepare a package. We have some wiggle room in there for depending on how difficult information may be to track down or how heavily documented you want to make that case. And then from obtaining the visa on the blanket level, it's all going to depend on the availability of the consulate. So right now, maybe it's going to be a few months. I'm seeing folks in Latin America, for instance, who just tried to get an appointment and there were appointments available, but they were out in September of this year. Other consulates are operating at more availability. So once you can get in, and the question is the big question is, right, where are you applying from? Once you can get in and have your case heard, the consulate will decide the case on the spot with the person sitting there at the consulate and whether it's approved or denied. And once approved, they should have the visa in about 5 days. If you file a case with premium processing, if you're not going the blanket route, and you file a petition with premium processing, the government will either issue one of these requests for evidence or issue an approval within 15 calendar days. At that point, you're back to the same question of, okay, now where can I get into a consulate? Ordinarily, we advise that folks will apply in their home countries. I did see a question pop up here that was, what if a potential employee is working in a country that is not their home country? So as long as that person has ties to the consulate at which they're applying, right? If they're, and ties would count if they're working there in that country, that's a third country. Generally, the consulate would entertain that visa. What the consulates tend to shy away from is what's kind of looked at as consulate shopping, right? If you go to some country because they got a slow wait time, but you don't really have any reason to be there other than applying for the visa, it's very likely that you could be turned away and asked to reapply in your home country.
Great, thank you. Sorry, just looking over questions here. If we don't get to your question, apologies. It just may be a little bit too specific to address live.
And Eric, let me just add a finer point on the idea of wait times. I also just want to raise that once the consulates do open, one can expect there's going to be a huge pent-up demand for these consular services. So expect backlogs for appointments to where popular high traffic consulates, especially somewhere like India, where only one of the consulates in that country does process L1 visas, you may have wait times of several months before someone can get in to apply for that visa, and that is an absolute prerequisite. You have to go through the consulate to get the visa before you can come to the US.
Got it. Great. So Ryan, what is a bachelor's degree or any higher education required for L1A visa?
The answer is it depends. There are certainly ways to look at the L1 application, and if the individual has, say, a foreign degree that's a 3-year bachelor's, doesn't quite meet the US equivalency, we can, in some cases, under the right circumstances, combine experience and have an expert witness retained to weigh in on that person's education equivalency. So the short answer is check with your practitioner because there may be workarounds.
Great. Let's see here. Yeah, it looks like we're at the end of the allotted time. I do want to be sure everyone has a busy day ahead still. Ryan, any additional points regarding the L1, things to keep an eye out for?
I think that about covers it. Welcome any questions that folks have.
Great.
After the panel, you can feel free to look me up and shoot me emails.
Yep, sounds good. And if you're an Envoy customer, definitely post your questions to the communication center. So Ryan, thank you so much for discussing the L1 visa today. Very informative. To our attendees, thank you so much for joining us this afternoon. As a final reminder, this presentation will be sent out tomorrow afternoon, as well as the slide deck and continuing education credits. All those materials will arrive via email, so please keep an eye out for that. And with that, have a good rest of your day and enjoy the rest of your week.
Thanks.
right, thanks.